A contract that is valid may be unenforceable. It may be unenforceable if it's not in its proper form, meaning that it's not in writing, not technically as to the substance of the contract. So there, as a general rule, the law that gives effect to oral contracts, of course, it's a good idea to have something in writing, but you don't need it to be in writing. Having it in writing certainly assists as proof that an agreement exists, but it's not a requirement for a valid and enforceable contract. However, by law, there are some contracts that are required to be in writing. If there's no written contract, then the contract is unenforceable. The original motivation for the rule was a concern over fraudulent testimony. Hence, we have the name Statute of Frauds. The principal function was to ensure that a person could not seek to enforce an obligation of the kind covered by the statute purely on the basis of unreliable and possibly perjured oral testimony, but would have to produce some adequate written record of the contract. So every state has a statute of frauds that provides what type of contract must be in writing. Meaning, and it doesn't necessarily have to be a formal writing, it just has to be documented, memorialized in a written form. An email could suffice. So what types of contracts must be in writing? Contracts that are required to be in writing. Anything that involves the interest of land. Contracts that cannot, by their terms, be performed within 1 year of the day after the contract's formation. Collateral contracts, such as promises to answer the debt or duty of another. Promises in consideration of marriage, and under the Uniform Commercial Code, contracts for the sale of goods priced at $500 or more. We'll talk about that when we get to sales, but that is something that is required to be in writing. So, interest in land. Contracts involving an interest in land must be in writing. This does not just mean a real estate transaction, a sale from a sale. A land also includes all the physical objects that are permanently attached to the land, buildings, sheds, trees, fixtures that are attached, like lights that are inside a home. But like I said, it's not always a transfer of sale to a sale. We could have something that's called an easement, where you grant an interest in property. An easement would be if you share a driveway in common with your neighbor or want to give somebody a right to cross on your land, you'd give them an interest. A common example is the utility companies have an easement in lands out front of your house so they can put telephone poles or lights. So any interest in land, a mortgage, would have to be in writing. It's a security interest in land. So anything involving an interest in land requires a written agreement. The 1-year rule. That one's a little trickier. It always stumps me up sometimes. A contract that cannot, by its own terms, be performed within 1 year from the day after the contract is formed must be in writing to be enforceable. Okay? Note that the 1 year begins to run the day after the contract was made. The idea behind this rule is that a witness's memory is not to be as trusted for longer than 1 year. Also, the expectation that long-term contracts may involve greater economic value. So, let's talk about an agreement here. Well, the rule. Contract that cannot by its own terms be performed within 1 year from the day after the contract is formed must be in writing. So you enter into a lease agreement, a lease for your apartment on May 30th, 2018 to begin August 15th, 2018, and it runs until May 30th, 2019. Does your lease have to be in writing? Does that comply with the 1 year rule? Does it have to be in writing? The 1 year period begins the day after the contract was made, so in this case would be May 31st, 2018. Can the contract be performed within 1 year? Yes, it can. So the statute of frauds, does it apply? No, it doesn't. So your lease does not have to be in writing. The statute of frauds does not apply in this instance. How about on July 1st, 2018, I made a contract with a popular resort to rent a room for a week from July 15th to July 21st, 2019, does this agreement have to be in writing? So work through the questions. When does this contract start to run? The day after it's entered into, so July 2nd, 2018. When is performance? Starts July 15th for 1 week, 2019. Does the statute of frauds apply? Yes, it does. This agreement has to be in writing. Even though performance is only for a few days, it's not going to be performed within a year. So the statute of frauds does apply, and performance, this agreement would have to then be in writing. Okay, this example. On today's date, Jason agrees to provide office cleaning services for Omar's Imports for as long as the company needs his services. Does the statute of frauds apply here? Meaning, does the agreement have to be in writing? The question you have to ask yourself, is performance within 1 year possible? You don't have any dates here except for on today's date. So the question I asked, so when does the clock start? It starts tomorrow. And the question is performance within 1 year possible? What if Omar's Imports goes out of business in 6 months? So if the contract, the rule here is if the contract by its terms makes performance within a year possible, the contract does not fall within the statute of frauds. So here, Jason and Omar's agreement does not have to be in writing because technically it can be performed within 1 year because Omar could close up shop. How about this example? I make a contract today with a farm in Iowa for 5 crops of tomatoes to be grown. Does the statute of frauds applies here? So I make the contract today, so the contract time frame begins to run tomorrow. So what kind of time frame do we have here? Does this need to be in writing? How long does it take to grow 5 crops of tomatoes? Five seasons? Is that longer than a year? Yes. This contract would need to be in writing. The contract performance must be objectively impossible to complete within 1 year. So if I'm asking for 5 crops of tomatoes, that's 5 seasons. We're probably looking at least 4 to 5 years. So this would have to be in writing. So possible versus impossible. If it is possible, Jason and Omar's agreement, then no writing. If impossible, then it needs to be in writing. So it's based on the terms and the famous objective person standard. What would a objectionable, reasonable person believe the circumstances to be? Can this be performed in 1 year? Is it possible? That's the question you're going to have to ask yourself. So the rules: the contract by its terms makes performance within a year possible. It's not within the statute of frauds. Contract performance must be objectively impossible to complete within 1 year from the statute of frauds to apply. And the standard, how do we determine whether the performance can or cannot be done within 1 year? It's the objective person standard. Next type of contract that needs to be in writing: collateral promises. What is it? What is a collateral promise? It's a secondary promise, such as a promise made by one person to pay the debts of another if the latter fails to perform. So it's refers to a promise to pay the debt of another that is ancillary to an original promise. So what would be an example of this? Frank contracts with Manco Machine Company to have some machines made to detailed specs for his factory. He promises Allied Supply Company, that's Manco's supplier, that if it continues to deliver materials to Manco, Frank will guarantee payment. So the question is, would this have to be in writing? We have co-signer situations. It makes sense that it needs to be in writing, because what would you have? Well, he promised to pay my debt. You'd have a he said, she said. So it makes sense that these kind of contracts would have to be in writing if you're going to kind of bind a third party or have a secondary promise. But in this instance, does this promise need to be in writing? So we have Frank, who contracts with Manco Machine Company to have his machines made to detail. He gives the specs. And Frank also promises Allied Supply Company, who supplies materials to Manco, that if Allied continues to deliver materials to Manco, Frank will guarantee the payment. Does that have to be in writing? Frank is guaranteeing Manco's payment or debt normally. Secondary promise needs to be in writing. Frank is promising to pay Manco's debt here. But in this instance, Frank stands to benefit, right? If Allied continues to supply Manco, Manco continues to make machines for Frank. So in this instance, he stands to benefit. Is there something different here? He gets his machines made. An oral promise to answer the debt of another is covered by the Statute of Frauds unless the guarantor's main purpose in accepting secondary liability is to secure a personal benefit. So in this instance, that promise does not have to be in writing. Does that make sense? Is that a good rule? I believe it's a good rule because it hangs everybody on for what they're supposed to be responsible for. If Frank's getting a benefit from Manco, Manco's getting the supplies from Allied, and Frank needs those supplies to go to Manco to get what he needs. So in this, everyone's kind of tied together versus a situation where you have a co-signer who agrees to pay the debt of another. You enter into a contract with the bank. I co-sign for you, and the bank can come after me if you don't pay. If we didn't have that in writing, you would turn around and say, she agreed to pay. And I could say, no, I didn't. So it makes sense when nobody has, when that third party doesn't have, or the initial party doesn't have the benefit. So collateral promises. Consideration of marriage. Not going to spend a lot of time here. That doesn't particularly happen. Promise to pay, to give property in consideration of a promise to marry must be in writing. Prenuptial agreements. They apply to this situation. Those agreements entered into prior to marriage and define each other's ownership rights in property. Those need to be in writing. And contracts for the sale of goods. I'm not going to spend a lot of time here because we're going to talk about it under sales, but we'll briefly, contract in writing for the sale of goods that are priced at $500 or more. Quick example. Coffee shop contracts with mug company to purchase 100 mugs for $5.50 each for a total of $550. Does this agreement have to be in writing? Yes, it would have to be in writing, even though one mug is $5.50. The total agreement or contract is for over $500. If the coffee shop buys 50 mugs for $5.50 for a total of $275, that does not need to be in writing. All right. When a contract falls within the statute of frauds, meaning that it has to be in writing, and it fails to comply with it, the contract is usually deemed unenforceable. But there are always exceptions that actually permit the enforcement of a contract despite the lack of a sufficient signed writing. So the exceptions are pretty narrow and specific. When might there be an exception? I have a blank spot. How about this instance? Two parties enter into an oral contract for the sale of land. The buyer paid half the amount, took possession, and started making improvements. So as we know, contracts involving land, interest in land, must be in writing. There's no writing here, but the buyers paid half the amount, took possession, and started making improvements. Do we have a valid contract? Well, one, we know that the statute of frauds does apply, but now we have the buyer doing some actions. So when parties enter into an oral contract and they begin performance, courts are likely to enforce an oral contract when partial performance has taken place. And it usually depends on the degree of injury that would be suffered if it wasn't enforced. Why would we have that rule? Does it make sense? Well, if we remember why the statute of frauds was created to prevent fraud, fraudulent testimony. When you have partial performance, it can establish that an understanding or contract does exist, right? A party who is performing and one is accepting the performance. So here the court tends to make a exception when one of the parties or both of the parties have partially performed despite the fact that their contract is not in writing per the Statute of Frauds. So in this instance, do we have partial performance? Sure. He's paid some of the money. He's made improvements. He actually took possession. What degree of injury would be suffered here? He would lose out on those improvements, and he already started working the property. It seems as though if the court said this is unenforceable, it would be hard to put the buyer back in a position that he was in before it all began, besides trying to pay him out. But if he wanted the property and he was making improvements, in this instance, the court would let this one go or issue what's called specific performance, which we're going to talk about when we get to remedies. Another example of when a contract that should be in writing under the Statute of Frauds but will be and is not, that will be enforced, is when a party admits the contract in pleadings or testimony or otherwise in court. That party cannot raise the issue of Statute of Frauds. So it's only to the extent of the quantity of the goods that are admitted. So this is what we call judicial admission. Okay? If somebody is actually admitting something in pleadings or testimony, what that means is they're under oath. They swear to tell the truth, the whole truth, nothing but the truth. So that if they admit to the contract in pleadings or testimony, the court is not going to allow them to then later raise an issue of the Statute of Frauds. And quick example, if that admission is made to your neighbor or friend, that's not enough. It has to be made within a judicial setting. John orally promises to give Anne, the manager of his farm, a certain piece of land if she achieves a specific level of success with the farm. Once Anne has performed, she requests the land. John refuses. Is this agreement enforceable? Does the Statute of Frauds apply? Let's start with, does the Statute of Frauds apply? Well, it's an interest in a piece of land. So yes, this agreement should be in writing. Is the agreement still enforceable? Under some other theory, maybe. We've crossed this theory a couple times. An oral promise can be enforceable despite the Statute of Frauds if, there's this promissory estoppel. Person making the promise, the promisor must foresee that promisee will rely on the promise. So the person making the promise must foresee that the promise will rely on it. The promisee will rely on it. There must be a way to avoid injustice. There is no other way to avoid injustice except to enforce the promise. Okay? So promissory estoppel. We've heard the concept of promissory estoppel a couple times already, and depending on where we are in the contract formation is going to depend on what type of elements that you're going to have to prove. So in this case, when we're dealing with the Statute of Frauds and we are required to have an agreement in writing, and it doesn't exist in writing, but we have a party relying on statements. We have a promisor. The promisor, in the circumstances, it must be shown that the promisor must foresee that the promisee will rely on the promise, and there must be no other way to avoid the injustice but to enforce the promise. So in this example, Anne, the manager of the farm, relies on the promise and works to a specific level of success. We can foresee that John would, his promise would be relied on. We could foresee that here. And now she's performed and she's done it and he refuses. Is there any other way that that justice is served? No. The court would have to require John to transfer the property to Anne. So those are the ways, the only ways that a court will void, I shouldn't say void, will allow a otherwise oral contract that should be in writing to be enforceable. So that's promissory estoppel, by judicial admission, and by partial performance. So what do we need in the writing? So we know those 5 types of contracts must be in writing, but what do we mean by a sufficient writing? To satisfy the Statute of Frauds, the written memorial of the agreement must satisfy a number of requirements. These are the requirements. You have to have a written memorandum. So it doesn't have to be a formal document laid out and double spaced and so forth. It can consist of any confirmation or configuration of a memorandum. It could be an invoice, it could be a sales slip, could be a check, could be an email, could be a combination of those things. It could be handwritten on a napkin, could be a single document, or it could be a series of letters, and exchanges. As long as it is enough to show the existence of the terms, the essential terms. So that's our next element, essential terms. All that is needed is enough to show the existence of the terms. We don't need every single term. Most of what we need in the writing under the Statute of Frauds would be the parties, who's involved, what kind of subject matter are we talking about? Maybe it's an interest in property. What's the consideration? If we're dealing with a sale of goods, maybe the amount or quantity. I need 500 mugs. And of course, the more terms and details you have, the better the agreement. But you don't need all of that. You just need the basics. Signatures is the other component. You need the signatures of the parties to be held liable on the contract, and it does not have to be at the end. It could be anywhere. It could be your initials. It could be anywhere in the document, as long as it has the signatures. E-signatures these days are acceptable. Ty signs a memo setting out the essential terms of an oral contract between him and Wilma. Wilma signed nothing. Can she plead the Statute of Frauds and the contract cannot be enforced against her? Sure. If her name or initials or her note, I don't know, maybe she just signs a big W for Wilma. If there's no signature from both of the parties, then it will be deemed unenforceable. The next legal rule that we have is something called the parole evidence rule. So this comes to play because this is like the reason why that we lay out the specific details as much as possible in the written document. We come to where we have a court having to interpret the contract. So this rule applies when an agreement is recorded in writing and one of the parties decides he wants to offer evidence to prove a term that is not contained in the writing or to explain or expand on a term in the writing. So what is the rule, the parole evidence rule? It's a rule of contracts under which a court will not receive into evidence oral statements or any extraneous evidence that contradicts a written agreement. They look at the 4 corners of the agreement in front of them. If it's clear on its face, that's the agreement. They don't want to hear, oh, well, this was supposed to be in here. Oh, this was supposed to be in here. No. This is why we have a Statute of Frauds. It's also based on the principle that when the parties reduce their agreement to writing, they often intend that the written document be the final expression of their agreement. So examples of prior negotiations, oral agreements that contradict or alter the written agreement are not going to be allowed. The court will interpret the agreement as it has in front of him or her, and use the ordinary meanings of words. But of course, it's contracts, and there are always exceptions to the rules. Exceptions. So when can a court hear outside evidence relative to a contract? In these 7 situations, a subsequent modification. So if there is a written contract and then later the parties have entered into a subsequent modification of the written contract, that contract can be introduced as evidence that there's a subsequent modification to the original contract. When parties are claiming that the contract should be voidable or void, we've already talked about how those things come about. It's an illegal contract. There was a minor fraudulent misrepresentation, a mistake. Outside information can come in based on a party trying to void or make a contract voidable. 3, this is a sticky one that always comes to play, ambiguous terms. Outside evidence can come in to show the meaning of a term if the contract on its face isn't clear. The court will take clear, plain language of the terms as we understand the words to mean before it will go outside to determine any ambiguous terms. Incomplete contracts, so it lacks one or more of the essential terms, i.e. if you have a real property transaction and you forget to put the property description in, that's something that is going to have to be heard as to, so what's the address or location or description of the property. So if there is an incomplete essential term, outside evidence will come into heard. Customary practices, this is usually with UCC dealings, and we'll talk more about this, where the parties had prior dealings. What's their course of performance? If there's a issue maybe with regards to shipping, was it freight train or was it a truck? What was their practices? What did they do? Obvious errors, clerical errors that would not clearly represent the agreement of the parties, those are allowed in. And this condition precedent. So I have that comes up. A lease agreement between the city of Plattsburgh and myself. I'm the owner of RLF Cheese Factory. The agreement is I want to put my restaurant or cafe in a city building. By law, the city council must approve all outside businesses that wish to operate in a city building. So that's the contract. If the entire contract is subject to an agreed upon condition, and this is like a forcible condition, it's not a agreed upon one. We can't say no, we don't need the city council permission, but we know that there's this outside source that the city council must approve the outside business. If they don't approve it, then there can't be an agreement. So there's a condition precedent before the condition can go through. So this approval is a condition requirement for the formation of the lease. If a dispute arises over the lease, the parole evidence rule will not apply, but oral evidence will be admissible to show whether or not the council has approved the terms and thus whether the lease is enforceable. So that if there's a condition precedent that operates the agreement or then puts the lease agreement into play, that condition precedent can come in as evidence